And now, Legal Perspective with Nick Clekis.
In South Carolina, the right to a speedy trial, guaranteed by the Sixth Amendment to the U.S. Constitution, has become more of an empty promise than a reality for many. To help us understand why, we're joined by Allie Menegakis, attorney with Clekis Law Firm. Allie, great to have you with us. I'll just go ahead and start it off by asking you, is it possible to get a speedy trial in South Carolina?
I would argue no. It depends on what your definition of a speedy trial is. I think when we ask the common person, if you were arrested today with a crime, how soon do you think would be soon enough to have a trial, which is your constitutional right? A lot of people would say a few weeks, maybe a few months. Some might say a year at the most. But the reality is that the wait time for a trial in Charleston County and a lot of the state of South Carolina is much more than that, looking at 3 to 5 years sometimes.
Would you say that's the average time it takes for a case to go to trial?
I would say in this county, you're looking, at least 3 years in this county, sometimes more.
Mm-hmm. Well, then we see these famous cases, right? These publicized, the Murdaugh, for example, right? I felt like he went to trial very quickly. Was it because of his level, right? What he upheld, or was it because of financial reasons? Why is it so different for people with money and a last name than it is for the average American?
It's interesting, and sometimes it's not any different for people with money. I think in that situation, you had both money and you had also public attention to that trial. Mm-hmm. The answer to your question as to why Mr. Murdaugh's trial was expedited as opposed to other cases who take much longer to get to trial is that it was the choice of the solicitor's office. In South Carolina, we are the only state in the country where the solicitor or the prosecutor gets to pick and choose who goes to trial and when they go to trial. Mm-hmm. In fact, our own Supreme Court has decided in a South Carolina Supreme Court state case that is actually unconstitutional, that it's a violation of separation of powers, yet we still do it every day, and we still do it here in this county as well.
I think I have my hardest time wrapping my head around the fact that, this is a constitutional protection that we have the right to a speedy trial, and that's not happening. Is this common practice in other states, or is South Carolina an outlier with this issue?
I would say that South Carolina is an outlier in the length of time it's taking for individuals to go to trial and the lack of recourse for individuals, especially that are in custody and able to go to trial. There are some options that defense attorneys have, which is filing a motion for a violation of a speedy trial or demand for speedy trial, but the problem is that our laws don't have any substance with teeth, that if you don't get that trial when you want it, that anything would happen to the prosecutor or the case itself. If you look at other states, for example, I used to practice in Florida. In Florida, if you are arrested for, let's say, a misdemeanor charge like shoplifting or maybe DUI, you must be brought to trial within 90 days. That is a speedy trial right for a misdemeanor. For general sessions or a felony charge, 180 days. If you're not brought to trial within that time and you don't waive that right to a speedy trial, then your case must be dismissed. We don't have that timeline here, and so everything is kind of delayed, and there's no real incentive, I would say, to push cases along. Mm-hmm. I think, a lot of attorneys and myself, I'm also the executive director for South Carolina for Criminal Justice Reform. We believe that the solution, or one of the solutions, is enacting a speedy trial right with teeth in South Carolina, similar to one in Florida, where there's an actual time period that your case must be brought to trial. Now, obviously, if we do that, we're going to have to invest more money into our judicial system. At this point in South Carolina, in Charleston at least, there are maybe between 2 to 4 terms of trial court a month. What that means is that maybe 2 to 4, at the most, maybe 5 cases actually go to trial a month in general sessions in this county. So if you do the math, if we have over 6,000 cases pending and maybe at the max only doing 5 a month, we are never going to get through this backlog.
And this is something that only people know if they talk to you, right, or they visit Clekis Law Firm, or if they're on the other end of this. So where can we go to learn more about your nonprofit and also Clekis Law Firm as well?
You can go to clekis.com. You can call us at any time, and we'll put the number out there for you to call us. You can also visit my website for South Carolina for Criminal Justice Reform. That's sc4cjr.org.
Wonderful, Allie. It's always a pleasure talking to you.
Likewise.
Thank you so much. We're back in 2 minutes.
This has been Legal Perspective with Nick Clekis.